Yeah, I start.
Alright. It's on.
Yeah, you get me some water, please.
No problem.
Good morning.
Morning.
How are we doing today?
Good.
Yeah?
Yeah.
Fantastic. This is the second of the three-part on international tax. And today we talk about transparency issues. Starting in the beginning with TIAs and tax treaties, doing some work on FATCA, and then the global standard of automatic exchange of information, which is now we know is CRS. So we know what TIAs are, right? The OECD came out with this initiative of tax information exchange agreements. Thanks, buddy.
No problem.
And voluntary compliance, following in the footsteps of who? The United States, right? They're always the leaders. They came out with the first one. So the OECD started this initiative back in early 2000s called Harmful Tax Practices, which was an initiative that really started out to try to encourage tax compliance and exchange of information. The OECD has a model TIA template. It's usually the template that we use. We have some variances, but it's basically the model. You can find it on the OECD website if you want to see what it looks like. It's about a, 15-page document that both countries sign. And that represents the standard tax information exchange agreement. Now we're familiar with tax information exchange agreements, right? So it's a bilateral agreement, meaning it's agreement between two countries. So we have one with, 27, 28, 29 different countries. And so it's a bilateral agreement that's been negotiated and signed between two countries that creates an official system of the exchange of information and tax information, financial information. But it's only on request. So a tax information exchange agreement isn't automatic like FATCA. It's not automatic like CRS, but it's on request. So a country requests information, and that information has to be what's called a proper request, which means it has to have all the elements of what's in the TIA. If it doesn't have all the elements and everything that's required in the treaty, then the country that receives it doesn't have to comply. So it's very kind of stringent. You have to identify the taxpayer. You have to know where the account is. They have to be subject to a criminal investigation on tax matters. So it's a list of things, right? Again, the requesting party must first make the prima facie case. So the requesting party must prove that he has satisfied all elements. Now, I fought TIA requests because of incomplete requests and gotten the government to not comply. So that is really what it hinges on, right? Hello. Again, it's not an automatic exchange agreement. It's an on-request agreement. And it's supposed to be a framework that prevents what's called fishing expeditions. So going out and trying to get all kinds of information and then put your case together. You're supposed to have your case together first and then make a TIA request. And, like I said, if you don't comply completely with the tax information exchange request, as the requesting party, the receiving party or the Bahamas can decline the request. And it's generally based upon, and these are other kind of policy reasons why, as well, you can decline the request. He's not exhausted all avenues of his own in the country to obtain the information. So if I'm France, I have to exhaust all my opportunities at home through my legal system to get the information before making this request. All right? This is kind of the policy basis. It never works. It's just a catch-all. Contrary to the public interest of the Bahamas. I mean, when is somebody's bank account contrary to the public interest of the Bahamas? Maybe it's a Bahamian politician. Who knows? It doesn't give the specific detail that's required, and it's not made in conformity with the elements of the TIA. So if you have a client, if you're a lawyer and you have a client or you're a bank, and a TIA request comes to you, what it's going to come to you, it's going to come from probably the Compliance Commissioner. The Compliance Commission is going to ask all this information. And you say, wait, how do I know it's a proper request? Right? You challenge them on it. Otherwise, they're just gonna try to get the information because they don't really go through the exercise. Right? So our history with TIAs. Our first one was entered into in the United States in 2002 and came in force in 2003. Remember we started talking about this and we said the United States was going to take away what? Our convention deduction. Remember we mentioned that? Where US companies can come in, have a convention, have a meeting, deduct the expenses when we were talking about income tax, right? And the US said, wait, you need to give us a TIA or we're going to take your name off the list of eligible countries. And so they strong-armed us into a TIA. And then the OECD followed suit after, remember? So the BFSB, they have a lot of good resources on this website, Bahamas Financial Services Board, but they have a list of all the TIAs that are entered into and if they're enforced or not. So as I said, there's a model TIA that's released by the OECD, and it's used by jurisdictions if they want to extend the scope. So we're now linking TIAs with automatic exchange, right? Because the TIAs doesn't stop with information on request. It now forms a part of the automatic exchange regime as well. You say, well, how? It's on request only. Well, if you are going to do CRS country by country rather than multilateral, we'll talk about that. Yeah.
Page you want? Sorry.
Page 15.
Thank you.
You're welcome. Come on in. I'm spinning, eh?
Not this weekend. That was rough.
The recovery was rough, eh?
I kid you not.
Boy, that's why I had to sit here and get fat.
Sorry.
No problem. So now, in 2015, the OECD said, well, let's see. We're going on an automatic exchange regime now, right? CRS. We have these TIAs. How do we link the two? So they came up with a protocol, which is really just an amendment that you can make to your existing TIAs if you would want to exchange information country by country automatically. It says you add this clause and it turns a TIA into an automatic exchange agreement, right? They did that for the purposes of bilateral negotiations. Now we'll talk about this when we do this CRS, but bilateral agreements have really not that material anymore because most countries, if not all, have signed up to the multilateral convention, which is instead of doing every TIA, amending every TIA, you sign one agreement that applies to everything, right? But this was for countries doing a bilateral. At the time, we were still doing bilateral. And so what we would have had to do is take this amendment to the TIAs, put it in place, and now we have an automatic exchange agreement through our TIA, right? Any questions on TIAs? Now, one thing, and we'll get to this, but we have CRS, right? And we have TIA, Tax Information Exchange Agreements. These are on request, right? This is automatic. They still work together, right? Let me tell you how they still work together, even in a multilateral context. CRS, as we'll talk about, is just a provision of information, right? The money, the income, the loss, the name, the account number, bank, whatever the information is on the Excel spreadsheet, the schema, that's you just produce that. Boom, 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 boom. It's not specific. So if I'm a receiving country of this information, and I say, wait a minute, my guy hasn't told me about all of this, and he owes me taxes. I need more information to understand what's going on. CRS is not a information request mechanism, so you can't go back and get more information under the CRS. The only thing CRS does is pump information out. They have to come back through the TIA to request information back, request more information. So they are linked, right? They are linked. So TIAs are still effective, but they're effective to complement what's going on now with CRS. You see? Yes.
Is there like a statute of limitations with any of the two?
Well, not with CRS, because CRS is just a production information. But when we talk about CRS, and I'll talk about it now, but we say, well, if you have TIAs, why do you need the CRS? Why do you need automatic exchange of information? Well, because under TIA, you have to have the information requested within 6 years. And the mechanism of going through the bureaucracy and everything else takes so long that in many instances it expires in 6 years from when the event occurred. So TIAs became ineffective because it took so long to mechanically go through it all and to get it right and go through the bureaucracy and get the information and send the information that they said, forget that. We're going to make you give us information automatically. Right? So yeah, 6 years. So FATCA. Right? Anything on TIAs? Nope. So FATCA. FATCA, we know, is a U.S. system, right? It's the first system of automatic exchange of financial information on a global scale. And who leads the way? The U.S. As always, right? So it's an important development in the U.S. efforts to improve compliance among foreign financial assets and offshore accounts, right? It requires foreign financial institutions to report directly to the IRS information on financial accounts held by U.S. taxpayers, right? Or an entity where a U.S. taxpayer has substantial ownership. So how many of you do FATCA reporting? Nobody here does FATCA reporting?
Shasta does it for us.
Shasta does it for you.
Give
I
her the
know.
information.
I owe Shasta an invoice. So, in FATCA, you report on U.S. persons, right? Only. Now, what's the timeline? This is the timeline that was for the implementation. I was the minister that signed FATCA into force in the Bahamas. So, timeline of FATCA. The FATCA provisions were in what's called the Hire Act in 2010 in the United States. Then they were noticed in 2010, another notice of guidance in 2011. Comments, remember we talked about the committee process in passing legislation. So this is what they mean for deadline for comments. It was in committee in Congress, comments, and then they released the proposed regulations in 2012. So by the end of 2012, we had the framework of what FATCA was going to be, right? And that makes sense because we entered into it, in 2013, I think, right? And so FATCA is entered into through intergovernmental agreements. We call them IGAs, right? IGAs are the mechanism between the two countries that operationalizes FATCA, right? And you have a Model 1 and a Model 2. Do we know the difference between the two?
Yes, I think so.
Yes, you think so? What's the difference?
Model 1 is where we Bahamas, we report to our competent authority, then report to the IRS. Model 2, they report directly to IRS.
Correct. So Model 1, financial institutions report information about U.S. accounts to the tax authority, right? The tax authority then provides the information to the United States, right? Now we have Model 1A and Model 1B. Do we know the difference between those two? What's that? Speak up, man. One's reciprocal and one's non-reciprocal. You read it, right?
Yeah.
What does that mean?
One where the information exchange between parties, and the other one is just you just send information.
And what's the Bahamas?
The Bahamas is non-reciprocal.
Non-reciprocal. Why? Because we don't have an income tax and don't need information on our people. Now, when we were negotiating, and I was up in Washington negotiating this, I said, I'd do a reciprocal deal if you give me customs information. Right? Then I know if you cheat in invoices and everything else. Right? But the U.S. wouldn't do that. So this is income tax. Customs is different.
Yeah.
You know, it's Treasury. That's the Customs Department. We don't mix. We know they mix. They're just being difficult. But you're right. We did a 1B. We're non-reciprocal. We're non-reciprocal. We don't collect information on our people. A reciprocal agreement is where U.S. gives information to country X on taxpayers of country X with accounts in the U.S. and country X gives information to the U.S. on U.S. persons with accounts in country X. Now we know all this money moving to the U.S. because of FATCA, right? Well, FATCA rules, or banking rules in the U.S. say you don't have to know who the beneficial owner is of an entity. Banks aren't required to get BO information like we are in the U.S. And so that's why people said, well, then they could only provide on entity information. So I can go set up a U.S. company, be the BO from country X, put all my money in the U.S., and the banks don't even know who I am, so they can't produce the information in country X. That's why they say the U.S. is the biggest tax haven. And that's why you see all the money going to the U.S. Because under FATCA, the banking rules don't exist to collect the BO information to report. Now that's changing. That's changing. But that is why you hear everybody say, the money going to the U.S., the money going to the U.S. Because they can't comply. All right? Model 2, you're right. The financial institutions themselves report to the U.S. Now only Switzerland and Japan, I think, are Model 2 countries. Everybody else is a Model 1 country. We chose Model 1 because we, didn't want to expose our financial institutions directly to the IRS. Our financial institutions didn't want to be communicating with the IRS. And we wanted a blocker, at least in the country, our competent authority, which is the Compliance Commission, I mean, as ineffective as they may be, they're still a regulatory authority in the country, right? And we also wanted, if there were any investigations of non-compliance, we didn't want the IRS coming to the Bahamas. We wanted that responsibility to lie on our regulators to do their own inspection and make their own determination. So there was a lot of kind of sovereign reasons why we preferred a Model 1. Right? So what's a U.S. person? Right? Because remember, if you have a Bahamas FFI, right, foreign financial institution, that has an account, and that account is owned by a U.S. person, taxpayer, right? That FFI has to report that information, right? That's how that works. So ultimately, you need to know who a U.S. person is in order to know what you're reporting, right? A citizen is always a U.S. person, right? Why? Because the U.S. taxes on worldwide income, wherever you live, wherever you make it. So a citizen is always a U.S. person. A resident of the U.S. is always a U.S. person, green card holder. So all them Bahamians that have green cards, right? The bank should be reporting, they should be paying taxes. All of them. Yeah, they know that.
I don't think they do it.
Hey, well, that's a different thing. Knowing to do it and doing it are two different things, right? A person residing in the U.S., so you can be a legal a tax resident of the U.S. without being a green card holder. You know, the 183-day rule and that formula and all of that. So that means that you're residing in the U.S. So all that Bahamians spending all that time going to the U.S., they're tax residents of the U.S., even though they don't have a green card. Next class, we'll go over how you determine that, right? A green card holder who never formally handed in their green card on leaving the U.S. A green card is the right to reside in the U.S. When you no longer reside in the U.S., it's no longer valid for immigration purposes. But if you hold it, it's still valid for tax purposes. So if you've moved and forgot to give it back, right? You're still taxable, U.S. person. And a child of a U.S. citizen that provided the parent lived in the U.S. for a specified period of time, these rules change depending on when you were born. Like I was born American, not born Jamaican. I was born American. I was born American because my mom's American. My mom lived in the United States for a period of time. Even though she had me when she was living here, I automatically took U.S. citizenship. Right? Now the PLP then made me give it up. Right? I'm not reportable by FATCA anymore. But if I still had my passport, like my brother still holds a U.S. passport, and my sister. You know, you got a passport?
What is the person?
You pay your taxes? You file your taxes?
Yes.
Good for you. You are way in the minority. Way in the minority.
What's the specific, time period?
For what? That depends on when you were born and how old your mom or your parent was, in my case my mom, when I was born. So the U.S. immigration laws changed throughout the years on if you are born to an American while not in America, there's a set of rules. If you're born in America, there's a set of rules. And so it's all immigration related rules. Right? So if you got an American mom or dad, we got to see if you were automatically American on birth. Then you got big problems, right? And so that's a U.S. person. So how does a bank know that you're a U.S. person? Right? Besides them giving you a passport. Passport, clearly you're a U.S. person. Right? There are indicia. So in FATCA, there's what's called indicia. And those are different elements that leads the bank to believe that you're a U.S. person and then report on you. Right? So U.S. place of birth is an indicia that you are a U.S. taxpayer. Your current residence is in the U.S. Right? You have a U.S. telephone number. And we all got U.S. telephone numbers, right? But we don't give them to the bank.
No.
Right? Standing instructions to pay to a U.S. account. That's indicia that you're in the U.S. Why else would you have the U.S. account? Now, that don't make a lot of sense, right? But some of these you can rebut, right? A current power of attorney granted to a person with a U.S. address and a whole mail account in the U.S. These are all indicia that the bank look at. Now the banks are getting self-certifications, right? The W-8s. Once you get a W-8, you can rely on that. But this is in instances where you don't have a W-8 on file. Say you have an account for the last 10 years. Now you got to review the account. The client says, I ain't giving you nothing. Right? So what are you going to do? You're going to close the account? Or are you going to do an indicia search? Right? I had a case where a bank hired me. And the person had a U.S. passport and was born in the U.S. but never had been to the U.S. Right? Never had been. Claims they ain't no U.S. citizen. Right? Not a U.S. citizen. Well, I said, there you are. Right? And the bank chose not to report him. Despite my legal opinion that they were a reportable person. Money is do some things, boy. Right? Serious. Serious. So we now know what a U.S. person, how to test for a U.S. person. Now we're doing W-8, so it's easy. Right? So the question is, who reports on who and how? What, why, how, and when, right? So we now have to do entity classifications. Now these entity classifications are important because they're fairly consistent for FATCA and CRS. Where there are differences, I'll point them out. But entity classifications are extremely important for knowing how to report and what to do, right? So you have, what's the next slide look like? Okay. So you have FFIs right? And NFEs. Foreign financial institutions, non-financial entities. Right? Now the key is an FFI reports on itself, right? And accounts that it has of passive NIFIs. I call them NIFIs. A NIFI can be passive or active. And we'll talk about this, right? But this is the important thing to know. An FFI reports on itself and accounts of passive NIFIs. So what's an FFI? This is where you have your entity classification rules, right? An FFI is defined as a custodial institution. So that's like a broker-dealer, right? A bank, anybody who custodies assets. A depository institution, anybody that takes cash, so your traditional bank. An investment entity, which is the major, for our purposes, in the financial services industry classification, we'll go through this. And a specified insurance company, right? Investment entity is most likely the one to focus on for your clients, right? So that's what we focus on here. So an investment entity, number of tests that you have to qualify to be deemed an investment entity. Remember, if you're an investment entity, you're an FI. If you're an FI, you report on yourself. So an investment entity is an entity that conducts as a business or is managed by an entity that conducts as a business, right? One or more of the following activities or operations on behalf, so you have to have one of the following activities, and it has to be or, so you're either doing the activity or you're doing the activity for your client, right? Trading in financial securities, so effectively trading in financial assets, right? Money market instruments, foreign exchange, interest, securities, futures, derivatives, right? You're doing portfolio management, right? Or you're managing and investing on behalf of other persons. That's an investment entity. So you're either doing that or you're managed by somebody doing that. Okay? Let's go over it again, because this is the key test. This is what Shasta troubles herself with all the time. Is my client an investment entity? Right? You're in the business or managed by somebody doing one of these. Portfolio management, trading in securities, financial assets, right? So, what's the next slide? Okay. So what does it mean to be managed by? Because managed by is the kind of default rule. So we look here, right? So I am an IBC, right? Or I have a client who's an IBC, right? That IBC, typical, has a portfolio of financial assets, right? And those financial assets are at the bank, right? The bank has those has custody of those financial assets, right? If I tell the bank how to trade those financial assets, am I being managed? No, because what does managed mean? Managed because of a discretionary investment management mandate, right?
It's like appointing an investment manager over the assets will be managed, like an octagon fund management.
Right. So, if I have an external asset manager, right, here, we know what an external asset manager is, right? Somebody who is in the business of managing assets. And I have the mandate to manage that portfolio. Now what has happened? I have gone from a non-financial entity, passive NIFI, to an FI because I have an EAM. Remember? Is managed by an entity that conducts as a business portfolio management. This is a company that is in the business of portfolio management and is managing on a discretionary basis the assets of this IBC. Remember, FFI, institution, you have to be an entity. Have to be an entity to be an institution. IBC is an entity. IBC has financial assets. EAM is managing those financial assets. I am now an FFI, this IBC. What does that mean? What does that mean? It reports on itself. Which means what? The bank doesn't report on it. Because the bank is an FFI, right? Because they are a depository institution. Remember the definitions? Depository institution. Bank is a depository institution. The bank is an FFI. What does that mean as an FFI? It reports on what? Itself and passive NIFIs, right? If I am a FFI here, what does the bank do to me? Nothing, because I'm not a passive NIFI, which means that the entity reports on what? Itself. Got it? Okay, we'll go over it again, because this is the crux of FATCA and CRS reporting for clients you have who are entity clients. Right?
Let's go with that again.
Yeah.
What's an FF? We have FFI and NIFIs. You get that, right?
Right.
We have NIFIs, we have passive and active. We'll talk about that, but just note we have two categories. Right? What is an FFI? It's one of these. It's defined. Custodian, depository institution, investment entity, and it's insurance, right? Defined. What is an investment entity? An investment entity is an entity that conducts as a business, right? Or is managed by an entity that conducts as a business. So it's either you or you're managed by you. One of these. Right? Trading in financial assets. Portfolio management. Investing, administering, or managing funds on behalf of other persons. Right? So our typical scenario in a client, we have this. This is your typical scenario. We get more complex, but this is your typical scenario. Client owns an IBC. IBC has financial assets. Financial assets are held with the bank. Right? Typical scenario. Client executes trades on behalf of the IBC himself, assuming client is an individual. Himself. What am I? I'm not an FFI.
No, you're not.
I'm not being managed. I'm not this company. What is this company? Is it an investment entity? No. It's not being managed. It's an execution account. Because the client has execution authority. It's not being managed. There's no discretionary management mandate to anybody. Right? So I'm not doing business, so I have to be managed. Right? An IBC holding financial assets isn't in the business of doing one of these things.
No, it's just holding. It's holding financial
It's just holding financial assets. So it's not in the business. Remember, you have to be in the business. It's not in the business. It's just holding financial assets. So execution account, I'm a passive NIFI. Okay? Execution account. Now let's go back. I have an EAM, right? That has the investment management mandate over these funds. I'm an EAM, that is a corporation, so I'm an entity. So as an entity, I'm an investment entity, so I'm an entity, I'm in the business of portfolio management, right? On behalf of customers. Because I as an EAM are an entity in the business on behalf of customers of portfolio management, I'm an FI. So I'm an FI. FFI. Right? Because I'm an FFI and I have an investment management mandate, my IBC is managed by an entity that's in the business on behalf of customers of portfolio management. And because I am managed by, I'm now an FI. And as an FI, I report on myself. We'll talk about what reporting on myself means, but I'll report on myself. Okay? Got it? Okay. Now,
So when you say passive, are you speaking about net income, passive and net?
we're going to go through the tests.
Okay.
Go through the tests. The income, it's an income and asset test. We go through tests. So this is a little bit of a difference between FATCA and CRS. It's now clarified because of subsequent rulings. But the question is, what else was managed by? Certainly managed by discretionary management mandate is managed by. But what if I don't have this, right? And what if I have here board of directors that are as an entity? Am I managing? And this entity is an FFI, right? Am I managing the IBC because I'm a corporate board of directors? This slide's a little dated. There were trains of thought in the early days of FATCA that yes, a corporate director or foundation counsel was managing the entity, right? Now it comes down to the discretion of management by that entity, right? If they are effectively managing all of this, then yes, it can be deemed managed by, right? It's the new W-8 form that came out last year. Read the instructions, clarify that position, right? So FATCA has what's called a sponsor regime, okay? So when I'm an FI, when I'm an IBC, I have U.S. taxpayer shareholder with financial assets, right, that are managed by an EAM, right? So I am an FFI. We got that right? I have to report on myself, right? Which means I got to get a GIN, Blue International Identification Number. I got to get a GIN, and I got to do FATCA returns with my GIN, right? That's what I got to do. Reporting on myself, y'all, Shasta, whoever, who does reports, right? File reports. Now, how are you going to have all these IBCs that are your clients that are FIs because they're managed report on themselves? All of them going to submit reports, right? I mean, it seems like a pain, and the directors are all over the world. You know, I mean, it's because the directors are the ones that ultimately now have to manage the reporting. That's their fiduciary obligation. So I have a client who lives in Wisconsin, who has an IBC of financial assets, and the board is in Brazil and Mexico, but it's a Bahamian FI, They're gonna do the reporting. They're farmers. They know what to do. So FATCA came up with this sponsoring entity, right? Which means another FI can sponsor the reporting of that FI. And so that's why banks will report on their clients even though they're FIs, because they have an agreement to sponsor. And they'll report under a sponsoring GIN rather than their own GIN. So you can get two GINs. You can get a sponsoring GIN or your own GIN. And so there are three requirements for sponsoring investment entities, right? You must be authorized, director resolution. Now you're seeing FATCA reporting agreements, right? Where you actually enter into an agreement with the other entity, right? The sponsoring entity must register as a sponsoring entity. So if this EAM is going to be the sponsoring entity, this EAM has two GINs. It has its own GIN, right? Of which it reports on itself because it's an FI. It's in the business of portfolio management. It's an investment entity. It's an FI. And it has a sponsoring GIN, which it reports on behalf of all of its clients who are also FIs, right? So it'll be filing two reports, one on itself and one on clients, right? And the sponsoring entity must do the required compliance to define if there are U.S. persons in those structures or not, right? Generally, the banks would know because of the due diligence that they need. Even the EAMs would know. The FTRA would give you, Financial Transaction Reporting Act, would give you enough information about your clients or make you get enough information for KYC and AML purposes to be able to do the compliance, right? The question has always been what is authorized to act. The new W8 again provides some clarity on that. Director resolution, director authorization, that's authorized to act. A lot of times in account opening documents, the resolution will have an authority to act in there, or the banks that have gotten smart in the account opening documents, they'll enter into a separate CRS FATCA reporting agreement that they'll charge for. You want me to file for you? It's going to cost X amount of dollars. I've seen it range from $500 to $2,500 just to do the report. Imagine that. You got 150 clients at $2,000 a pop. Yeah, that's real money. That's real money, right? And it's good money making. In fact, I know companies who are financial and corporate service providers who force themselves to be FFIs so they can do the business of reporting on on other entities, right? So it's a business line. It's a business line, right? This one's my favorite, right? Why is this one my favorite? Because I did it! Yeah, somebody was paying attention last class. Who gets the gold star? Yeah! So trustee documented trust, right? So trusts don't fall under the sponsoring entity regime, right? Because of quirks in the definitions and FATCA and everything. So you couldn't have a trust be sponsored under the sponsoring entity regime, which means that every trust that's an FI, right, has to report on itself and get its own GIN. When you get its own GIN, that's public information. And now you've created a public trust registry. Because most trusts are FIs because they're managed by an institutional trustee, and that institutional trustee is in the business of managing. That's what they're in the business of. That's what trustees do. So most trusts, because of the fiduciary obligation given to a trustee and the powers of a trustee, are FIs. And so without any type of sponsoring regime, you've now created a public trust registry of all trusts in the jurisdiction. And all trusts in the jurisdiction have to self-report. There is no sponsoring regime, so all trusts in the jurisdiction have to do their own reporting. Think about that. One, we don't know how many trusts are in the jurisdiction because we don't have a trust register. But all trusts that have institutional trustees would be FIs and have to undertake themselves, right, the trust, the FATCA reporting. So we did say we need a trustee documented trust, whereby the trustee undertakes the compliance and documents that none of the trusts it has have U.S. persons, or these trusts have U.S. persons and reportable. So there is never any public. There's no public GIN. There's no public reporting of entities who don't have U.S. persons. You're documenting that nobody that you have management over does, and so we keep our financial privacy to the extent it's non-U.S. persons in the trust. Right? This was another issue early on. Early on. So we talked about sponsors, and you had the sponsoring GIN, and you had your own GIN when you sponsor somebody, right?
Right.
So a trustee documented trust, the question was, which GIN should be used when a trustee has an FI GIN and a sponsor GIN?
PTC has what they call a lead gen, so if we're sponsoring a trust, we use that gen number.
Yeah. Early on, there was no clarity on this issue. And there were conflicting opinions, right? One opinion was, well, I'm a trustee, I'm acting in my capacity as trustee for these trusts, and therefore I should use my own GIN, right? The other theory was, this is akin to sponsoring, and you should use your sponsor GIN, right? Very technical argument, right? And the fact of the matter is, if you get it wrong, you've now filed a bunch of wrong FATCA reports, and you're subject to penalty, right? And so a trust company called me, not PTC, early on, right? And said, actually one of my good clients, said, what do? We don't know what to do. This was the first year of FATCA reporting, right? We don't know what to do. We want a legal opinion. I said, Ryan, but you are a Bahamas lawyer, so we're going to get a legal opinion out of the UK, and we're going to get a legal opinion out of the US, and we're going to get one from you. Right? Because you was in a banana republic, right? If they trusted my opinion, they wouldn't have to get the other ones, right? They're just doing it because.
Right.
So I said, use your sponsoring GIN. It's akin to a sponsor, right? You are taking the activity as another FI, so use your sponsoring GIN, right? The other two said, no, you use your trustee GIN, right? I said, okay, no problem. No problem. Out comes the new W8 Ben a year later. And what does it say? So much for a banana republic. And I'm sure my opinion was cheaper than the other two ones too. Because they don't like to pay Bahamian lawyers either. Right? You do a $100 million deal, the lawyers in London making $2 million, they want to give you $10,000.
Did they ever come back?
Yeah, they're one of my best clients. They're one of my best clients. They know they were wrong.
They will not make that mistake again.
They don't make that mistake again. They don't make that mistake again. Right? So we have done FIs. We got FIs, we got how they report, we got how they're sponsored, how they're trustee documented, entity classifications, you're reporting on U.S. persons. We got it, right? Okay. So the other category is non-financial entity, the NIFI. Right? What is a NIFI? Everything that's not an FI. That's easy, right? So that's why we start with your entity classification rules and understand them. Because that's the first thing you have to do when you're asking to classify entities and do I report on this entity or this entity? Do I not report because it's an FI? What is an FI? An FI is this. What is a NIFI? Everything else. Okay? And now you have active and you have passive. Right? And these are very important classifications here as well. Why? Because active aren't reportable entities. They're not reportable. Which means if you have two entities that you're doing FATCA reports on, and one you say, you're a bank, and you say, this one's an active NIFI. You know what I do with this one? I put it over here and don't pay no attention to it. I don't report it, I don't do due diligence on it, I don't do anything on it. From tax point of view, you have to do it from AML. But from a tax reporting point of view, I take it and I put it in the corner. You don't do anything. You don't report active NIFIs. So what does it matter? Non-reportable, right? You only report passive NIFIs. So what's an active NIFI? In FATCA is always, you have the test and then you have everything else. You have the test, you have everything else. I have an FI, I have everything else. I have active NIFIs and I have everything else. So you see if it's an active NIFI, right? And it's always in the negative. This is what I hate about these things. It's not in the positive, it's in the negative. When less than 50%, right, of the gross income, so we have an income test, right, for the year, right, is passive income, and it's both tests, right? And less than 50% of the assets held, right, produce or are held for passive income. So if you flip it around, more than half of your income and more than half of your assets are active assets, active activities. You're an active NIFI, right? So if I have a company, right? So let's say I have a U.S. taxpayer, BO, that has an IBC, right? This IBC has offices. They are doing, they're a development company, right? They're Baker's Bay, right? They're Baker's Bay. They're in the business of the property development in the Bahamas with a full staff and a full office and a sales team and this and a that and a that and a that, right? Their assets they have are held for active business, right? And the income they're generating is a result of their activities of a real estate developer and therefore are tied to active, right? And therefore they're an active NIFI. And therefore, if I'm the bank that is banking their assets, I don't report at all. Think about the logic of it. Apple Computer. Apple Computer is an active business that has companies and bank accounts all over the world. Imagine if you had to report on these business units. That's not the purpose of FATCA. The purpose of FATCA and CRS are people who are hiding money, not people who are in the business of doing business globally. Right? General Motors sells cars all over the world. You want to report on them and get all of their shareholding and all that kind of stuff? No. Right? So that's the theory of exempting active NIFIs out of reporting. Right? So I had a client, right? I had a client who's a U.S. taxpayer, right? And he had a structure. His structure was like this. 2 IBCs, right? One IBC is where he kept his financial assets, and one IBC he had active business. And in that active business, right, he had bank accounts and everything else that were clearly related to his active business, that carried very high values, right, because he was doing cross-border deals. He had a lot of business income in there. And so he said, well, am I reportable? I said, not here, but yes here. Because this was an IBC that just held financial assets. That was not managed. This was a passive NIFI. Right? Passive NIFI. This was an active NIFI. Right? So he said, well, what do I do? I said, well, you move this bank account over here. And you get rid of this. And because you're carrying such high balances here, related to the business,
Ain't nobody with you.
well, you're less than 50%
Right.
of your assets and income is related to passive activity. So you're still an active NIFI. So now you've taken all of your passive assets out of a reporting regime just because you stuck them in your active business.
Okay.
You criminal? What's the difference between tax avoidance and tax evasion?
Right, yeah.
It's just reclassification.
Tax avoidance.
That's why you gotta know the rules.
Yeah.
That's why you gotta know the rules. That's why they pay me the big bucks. Alright? So who do you report as a passive NIFI? I, B, C, execution account, right? U.S. taxpayer. Who do you report? You report on controlling persons, right? Controlling persons. Ooh, see, I got you through this without even telling you what a controlling person is. Controlling persons are persons who what? Who own less than 10% of the entity, right? We mirror our AML standards on this. Our AML standards, central bank AML standards say you do due diligence on people who own 10%, right? So what if I own 9%? But I'm a U.S. taxpayer. I don't have any controlling persons, so I don't have any reportable persons. So if I don't have any reportable persons, I don't report on anybody. Right? Easy test for controlling person. FATCA. Any questions on FATCA? Entity classifications on FATCA are imperative because they almost mirror themselves between FATCA and CRS. So I'm not going to go through entity classifications for CRS. I'll only point out some differences. But those are the baseline rules for all of your classification and entities on FATCA and CRS. Okay? Look sad what happened? You alright? Alright. Alright. You say so.
Sorry, Ryan, I going off too, like, that's coming late. So we were doing TIA, why didn't the Bahamas instead of TIA actually sign TTAs? And what's the difference?
Okay.
Sorry.
No, that's a good question. What's a DTA? Double tax agreement.
Right.
What does a DTA do? So you have a DTA, and what it says is, where do I pay tax? In country A or country B?
Right.
Right? I am a company from country A doing business in country B. And the question is, where do I pay tax? Do I pay tax in A or B? Right? A double tax agreement says if you have what's called a permanent establishment in B, you pay tax in B, even though you're from my country. But what do you need to have a DTA? You need to have a tax. We don't have a corporate income tax. So we have no grounds for a DTA.
Okay.
If we have a corporate income tax, then you can have DTAs. Okay? Barbados has a corporate income tax. They have double tax agreements. Okay, the common reporting standard, right? And I always say there are three aspects to the common reporting standard, right? You have what's called the standard, and people confuse this. They say, see, the standard, that's CRS, right? No. You have the standard, and the standard is when the world said the standard globally is now the automatic exchange of information. Before the standard was informational request. Now the OECD says in July 2014, says no, the new global standard is automatic exchange of financial information. You're going to do it according to the rules of the Common Reporting Standard. The Common Reporting Standard are the actual rules. They're the due diligence rules, they're the guidance notes, and everything else. Right? So the standard is what's pronounced by the OECD according to the rules of the CRS. Right? and then according to the way a country chooses to implement. Now, I still teach this because this is still law, even though it's not policy. Right? A country can choose, and this is taken out of the CRS, okay? This is taken out of the CRS, and taken from my personal conversations with Pascal Saint-Amans, head of the OECD, when I was minister. Right? So don't let them lie on Ryan Pinder now. Right? A country can choose the basis of implementation of the standard according to the rules of the CRS. Right? And they can do so by bilateral agreement or multilateral agreement. FATCA is based on a regime of what? Bilaterals, right?
Yeah.
Those are what the IGAs are. Those are how you choose your model 1 or model 2. Right? Bilateral. Every country has an agreement with the US. Every single country has an IGA. Or multilateral, where you sign one agreement that applies for all of the signatories. Right? Ryan Pinder, as minister, thought a bilateral approach was proper. Why? More aligned with FATCA. Right? Gave you a little bit more sovereignty and control over the process. You didn't lay down and let the French and the OECD trample over your back while you're still complying. Right? Privacy reasons. Right? But Ryan Pinder got overruled at the end of the day. Well, I was long gone. I let them take the fall for getting bullied. See, I bullied back, and they didn't like it. Right? They didn't like it. I went to the University of Wolf Road. That's how you go. Now I from Lizzie remember. Right? Home fabric straight in the heart of Mason's edition. You know where we come from. He's a Saxons from the east. So the multilateral convention. It's broader than the common reporting standards. The multilateral convention has terms and conditions that are in excess of the rules of the CRS. It's one of the reasons why I didn't favor it, and I still don't favor it. Right? It covers a wide range of taxes, so it doesn't just a financial reporting regime that you pump information. It covers taxes, inheritance tax, social security tax. It includes a spontaneous exchange of information clause, which is craziness, right? Craziness. Remember avoidance and evasion? This completely washes that down the toilet, right? Where you become aware of information which could foreseeably have tax implications for another party, right? Including savings of tax, right? So let me give you an example. Remember this one? You have an investment fund owned by a Brazilian, right? Declared to their country that has financial assets. And what are we trying to accomplish here? Come on. Deferral. Remember? Defer tax, defer tax, defer tax. That's tax avoidance. It's legal. It's proper. It's endorsed by home countries, right? And it could foreseeably have tax implications to the other party, to Brazil. Why? Because it's deferring the tax. Remember, you're compounding the growth and it's growing. Remember those calculations we did? Right? So now I have to spontaneously let the Brazilian authorities know that I have a structure that is lawful and legal and declared already to them. Right? And then it confuses the Brazilians, and the Brazilians audit my client, and then my client says, what the heck am I doing in the Bahamas? It's only causing me headache. It's a ridiculous clause. Now we signed up to it. So that's when I say the multilateral convention is broader in application just to automatic exchange of information under the CRS. All right? Other elements where the multilateral convention are broader than the common reporting standard. You can have simultaneous tax examinations in their own territories, right? The whole purpose of the FATCA and a Model 1 approach is so we don't have people coming into my countries and doing any kind of tax investigations. I give it to my regulators. We have now allowed foreign tax authorities to do simultaneous investigations by coming to our country. Right? Craziness. Where's our sovereignty? Might as well be a colony.
What to say?
How are these fellas treating us? I can go off a little bit. I had the French ambassador in my office a couple months ago, right? He lives down in Panama. He's the ambassador for here. Boy, I already don't like the French and the OECD, right? Somebody told him, listen, you gotta go talk to Ryan Pender. He knows what's going on. He'll give you a good context. Oh, that was a mistake of his life. Oh, that's a mistake. And this is right after the EU blacklist, right? Oh, I brought him in. I wouldn't even let him start. I said, tell me, Mr. Ambassador, where in the world do you have the authority in the EU to blacklist the Bahamas as an independent country? When we're complying with what you want to do, when you want us to do more than the OECD wants to do. And you're not even doing it yourself. Well, I row him hard.
So what did he say?
Well, Mr. Pender, I think you just have to accept that what we say is the right thing to do. I said, listen, Mike. I said, listen to me very carefully. Very carefully. I am. No, he wasn't my client. And I don't know. I can't stand it for it. I said, do we look like a colony of the European Union or France? Do we look like it? Are we an independent country? So we can make the decisions to do whatever the heck we want to do. And my decision, my opinion is, you're wrong. Well, he hightailed out of my office. I row him so hard. He called me on a bad day. Right? Bad day. So I'm sick and tired of international institutions, primarily led by the French and the Germans, imposing obligations that are broader than commitments we make. Right? We made commitments to the OECD under BEPS, and the EU tells us we have to go even further. I told one of my colleagues the other day, are we going to recognize that there are international institutions that are in charge of these areas, OECD on tax matters, FATF on AML matters? Or are we going to say, you have no application because the EU says they want it done a certain way? Ryan Pender ain't in politics no more. Right? So, these are examples on how it's broader. Now, why I said the bilateral approach would be better on CRS, right? And it is legitimately an option. Go read the introduction and the executive summary of the Common Reporting Standard. They spend a whole page and a half on this. Right? It's similar to FATCA, right? It's limited to the rules of the CRS. Why would we want to do all of those other things? When our only commitment is to the standard. And the standard says it's the global standard, it's the exchange of financial information. Not spontaneous exchange of information, not allowing simultaneous investigations in your country. The global standard is automatic exchange of information. A bilateral approach confines you to what you have agreed to do. Right? It allows you to make limited, but some divergence with respect to the CRS. CRS allows you a little bit of wiggle room, and you can negotiate those in bilateral agreements, right? And it preserves the requirement of confidentiality. They got to keep the information confidential, right? And so what's the difference between FATCA and the CRS? Where are some of the differing characteristics, right? We know FATCA is U.S., based upon income of U.S. taxpayers, and it's exclusively bilateral. CRS is global, now effectively multilateral. We caved from our bilateral position effectively when Hong Kong switched. Because the only remaining countries that were pushing bilateral were Singapore, Bahamas, Barbados, and Hong Kong. Barbados always tries to follow the Bahamas and then to say they're in the lead. Right? But Singapore was the first to fall and Hong Kong was the second, and then that was it. Right? Bahamas and Barbados. Ain't nobody checking us. Right? And so this is how I call it, right? Because there's different applications in CRS that makes it broader than FATCA. So FATCA sits in CRS, right? But for instance, I'll give you one example of how this is. FATCA, we all know what a protector of a trust is. Have you done that? We know that, right? FATCA, no reporting on protectors. CRS, reporting on protectors. This is how it's illogical, right? A protector doesn't own anything, right? Isn't even really taking a fiduciary obligation. It's just ensuring the trustee manages the trust appropriately according to the trustee and the intent of the settler. Under CRS, you have to report the trust assets to the protector's home jurisdiction, even though he has no ownership. You don't know how many protectors we've taken off trust because of CRS. Crazy, hey? So imagine if I'm in the UK and I'm a protector of my friend's trust, right? He asked me to be the protector. My friend's trust is in the Bahamas. The bank account's in the Bahamas. The settler of the trust is in Spain, right? And the trustee, it says in Switzerland. You know what the report is going to go to? It's going to go, all of the trust assets are reported to the UK, because I'm the protector, to Spain, because he's a settler, and to Switzerland, because he's a trustee. So the UK turns to me and says, Ryan, where's my tax money?
Exactly.
What are you talking about? This ain't mine. I got this report. So now I'm enthralled in an audit and everything else from acting as a protector. And my friend's information has now been reported to the UK. And he's never goes to the UK. Craziness, eh? Craziness. Craziness. So now you know what you do? If you have a trust, this is a little practical advice. I didn't even charge you for this, right? Right? And you have the trustee here. Do we know what this is? Bahamas Executive Entity. It's an entity that we have. It's like a foundation. Has no owners, no shareholders, and can only do prescribed functions that are executive in nature in law.
You don't really sell that as a
All right? You don't understand it.
Bahamas and
Executive entity, the B, right? And it has a council, which is a decision-making body, right? And so what you do is you put the client here, right? And you put advisor 1 here and advisor 2 here. These 2 advisors are in the Bahamas, right? This guy can be anywhere he wants. The B is the protector. The client has influence, although not control. The control is located in the Bahamas, so no reporting on the protector.
Wasn't this lady Carolyn Garner, that was her name, who was like very influential?
She helped draft the
in that?
legislation, yeah.
But we don't.
Right? So you should use a B in every protector. Put 2 Bahamians to one on the client. You want me to draw that bigger so you can see it?
Yes, please.
All right, I get it. So you have a trustee, right? That is trustee of a trust, right? That trustee has a protector, like most trusts, and instead of that protector being an individual, it is a Bahamas executive entity, right? Which is an entity in the Bahamas by statute. A Bahamas executive entity has no owners and no shareholders, so no controlling persons by share ownership, right? Bahamas executive entity has a foundation, has an executive council that is the governance of that entity, right? And so you make a 3-person executive council, and you put the client as 1, you put a advisor as the next two. Whoever the advisors are, you could scatter the countries, or you can put 2 of the 3 in the Bahamas. In any event, there is no controlling block in a particular country or in a particular person. So because there's no controlling block, there's no controlling person that has effective control, and therefore it's not a reportable person as a protector under CRS. Okay? The best thing is to have 2 Bahamian resident people here, or entities, because if it's Bahamian resident, there definitely isn't any reporting because it's in the Bahamas, right? You report on tax residents of other countries. So then you take the protector entirely out of scope while still leaving the client or his designee with the influence he needs practically to control the protector. And if somebody dies, you don't have to amend the trust deed because the entity is the protector.
Right, so they can just appoint somebody.
Right. Right? And so for all your trusts now, in the context of CRS and the disclosure of protectors, you should be using executive entities.
No reporting,
Right? And under the new the guidance, the new guidance we just did on CRS, so you know you have a settler here, right? And then you have beneficiaries, right? This is practical. This isn't on the test, but this is how you should structure your stuff, right? If this is irrevocable, that's irrevocable. The settler is still a reportable person, but he's reportable at 0. We're one of the only countries that have that in our guidance. Because it's irrevocable. He doesn't own it anymore. So you can't say the settler is not a controlling person because the CRS says he's a controlling person. Always. It's always reportable. However, our guidance note says if it's irrevocable discretionary, you report it at 0. Right? Beneficiaries 1, 2, and 3, we have a discretionary trust, right?
Right.
We have elected, which is one of the elections we can do, you only report when there's a distribution. If there's no distribution that's not reportable, the beneficiaries aren't reportable.
Okay.
All right? In a discretionary trust. All right? So if we set this up and there's no distributions for the year, and this is set up like this, what's reported?
So what if,
Just a 0 report on the settler.
so I,
Beneficiaries aren't reported and protectors not reported.
I have a question. So what if we have beneficiary owners, right? We did a distribution and one of the beneficiary owners is a US person.
Well, if it's a U.S. person, then you got all kinds of other messes going on. But that's a FATCA report, right? If it's a CRS report, you have a French beneficiary and you give a distribution, you have to make a report to France to the amount of the distribution. That is also in our guidance notes now, not the whole
The
value.
whole volume.
Okay, so amount of the distribution.
Okay.
Right? But that's how you want to set them up. You want to fix your protectors on CRS related matters to your trusts. Your protectors probably don't even know they're being reported on. I guarantee you they don't know.
Oh, we had one who said he's not, because we had asked him for CRS forms, and he said, why do we need it?
So you put this in,
He's
and you
not
put
saying
him
it.
as one of the foundation councils, and you act as the other 2.
Do you have a suggestion, Mr. Shasta?
Just only causing issue in trouble. That's what you should. And you're making money on the B.
Right.
It's a service provider. They gladly have you incorporate a B and take $1,000 or $2,000 a year to be on the executive council to not have them reported. And the settler would pay because the settler has this guy as a protector for a reason. It's his trusted person. There's a reason he's a protector. And the settler's not going to want the information exchanged into the protector's home country. It's his private information going into another country with no application. It's an easy sell, man. Easy sell. Make some more money. Right? Make some more money. So, again, CRS, same types of entities, right? We're not going to go through the classification exercise, but the same types of entity. This, except you have an additional type of entity, right? Unless one of these entities present a low risk of being used for evading tax and are excluded from reporting. We have defined a couple of these in our guidance. Central bank, right? Government entities. So it really doesn't cover anything practical. So it's just fluff, right? What is reported? All of you guys are doing CRS reporting, although I don't think many of you are. Interest, dividends, account balance, income, sales proceeds from financial assets, other income, right? Of course, like FATCA and everywhere else, you look through the entity to the BO. That's how you report. That's the controlling person, right? So we're going to run through some of these due diligence rules real quick. And then I think after that we're done. How many more slides I got? Plenty?
Yeah.
All right. No, this is free classes. This is free classes. Folks, we have a tax class on Tuesday, Ms. Archer. Please. Tuesday.
Tuesday what time?
6 to 9. It is. She has a lot to cover, man. That's a big section. We ain't gonna go in the middle of December. Correct?
Okay. So Tuesday and Saturday?
Tuesday and Saturday. Alright? That's one Tuesday. That's the makeup for these missed classes, please. Thanks.
Well, ain't got nothing to do Tuesday night. Wow. So we're going to run through some of these due diligence rules. We're going to run through them kind of quickly because fact of the matter is everything is done by self-certification now. So these were applicable when it first came into effect and you were doing new accounts versus all pre-existing accounts, pre-existing high value, pre-existing low value, entity individual, and then the Bahamas issued a timeline on reporting for the different ones, okay? Right now, practically speaking, almost all institutions just send their clients self-certifications and tell them certify what you are. Why? Because then they don't have to make a determination themselves and they just rely on that, okay? So, the due diligence review, right, you have to do a review of your clients. Certainly this is applicable mostly entirely to pre-existing clients. New clients have to have self-certifications. Pre-existing clients, you can make this determination or get a self-certification, right? You have different procedures between an entity and individual account. So you have an entity account and an individual account. There's different procedures. You have different procedures depending on the value of the account. High value, low value. The value account is $1 million between high value and low value. Right? All y'all work for big time institutions. Mm-hmm. Most of your clients are high value accounts, right? 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 So what are the rules for pre-existing individual accounts, right? These are easy. These are individual accounts that existed before July 1, 2017, right? That are low value. All you have to do if you don't have a self-certification is do a permanent residence test based upon documentary evidence, right? So I give you a residence card. It's a low value individual account. You can take that as substantiation of where my tax residence is. The theory is there's low risk of tax evasion here, less than $1 million. No complex structures held by an individual. For high value individual accounts that pre-existed, our pre-exist date is July 1, 2017. Right? Every account after July 1, 2017 are new accounts in the Bahamas. High value accounts, you need enhanced due diligence, which means you have to do a paper search, a record search, all the AML searches, all of those to determine tax residence. Right? and you have to factor in a relationship manager test, right? Which is actual knowledge. So, which means that if I'm a relationship manager for a bank, and I only visit that client in Lugano, when he comes from the train from Milan, he lives in Italy, never's here, but he has a permanent residence card that says he's a permanent resident of the Bahamas, relationship manager knows absolutely that's not true. Right? So the institution has to have a relationship manager test on where the residence is as well. You know, these relationship managers, they ain't all into that. Right? Now we're talking about pre-existing entity accounts. Entity accounts that exist prior to July 1, 2017 on the books of the bank. And you don't have a self-certification. What do? Okay? You got that? So this is, financial institutions are required to determine whether the entity is a reportable person, and that could generally be done on AML purposes, right? If you're if the entity is a reportable person itself, meaning it is an FI, right? You gotta make that determination. If the entity is a passive NIFI, then you have to report based on the residence of the controlling persons. Remember, if I'm a bank and I have an account for an FI, I don't care. It's the FI's responsibility, not mine. That's why some Swiss banks are only taking FIs. They're not taking passive NIFIs anymore. You don't want the reporting hassle. Well, it's yours. Oh, it's yours? I'll do it for you for a fee. All right? So for high value, pre-existing entity accounts, right? High value, pre-existing entity accounts. Enhanced due diligence applies again, which includes a paper search. So you have to do the indicia, and then you have to have a relationship manager test. Right? Now this is something we chose. If you have a pre-existing entity account, right, below $250,000, they're not subject to review. So what a lot of clients who had less than $1 million in the country did, they split it up between the banks. All of them less than 250, they're not subject to review. So the assets stayed here but are not reviewable by CRS. Crooks. Again, all new individual accounts require self-certifications. So that makes it easy. After July 1 or at July 1, 2017, you open up a new account, self-certification is required. So you don't have to go through those due diligence rules, required. Right? For new entity accounts, the same assessments are made. So it's not mandated on an entity account, but I don't know an institution that doesn't get a self-certification from a new entity account either. And so they send out the self-certs on the entity, on the controlling persons, right? You get all the self-certs back on the entity. Why do you need a self-cert on the entity? Because they'll tell you if it's an FI or a NIFI. If it's a NIFI, they'll tell you who the controlling persons are, and then you get the controlling persons to themselves fill out a self-certification saying where their tax residence is, et cetera, et cetera, et cetera. And then you just have that in your reporting framework. Right? And so self-certification, OECD has forms. Remember the W8 started out, what, 2 pages? Remember that? How many pages it is now? Gotta be 20-some pages, right? Same thing's gonna happen here. And I have banks, I do a lot of CRS policies, procedures, onboarding policies, client acceptance policies, and I actually do self-certifications for banks. I've probably done them for about 4 or 5 banks here. I've done the whole CRS policy regime. I haven't done it for PTC. They didn't hire me. But what we do is now we combine the W8 with a CRS self-cert, so you do one self-cert, right? Because that W8's not required. The information on the W8 is required. So you can combine it into one. For CRS, what your self-certification has to include the account holder's name, address, jurisdiction for tax purposes, and the TIN for that tax purpose. That's all that they require. Now people put more stuff in there. Like for instance, if I have a self-certification for an entity, I'm gonna want them to list on that who the controlling persons are, so I can follow up and get my self-certs there, right? If you have reason to know as an institution that the self-certification is incorrect, you have an obligation to get a correct one or back it up with documentary evidence, right? So my Italian that lives in Italy sees a relationship manager in Milan or in Lugano, has a PR here, does a self-certification that he's a tax resident of the Bahamas. I have reason to know it's not correct. I have to go and get a correct one, or to have him tell me or give me information to rely on that is in fact correct, right? And so it's the bank who has to decide what documentary evidence is sufficient, right? What I'm at,
But if you don't know, you don't know. If they declare something and you don't.
if you find it to be,
otherwise,
but you have to have reason to believe it's
it's
wrong.
different, right?
If you don't have reason to believe it's wrong, right, then you're okay, right? So, again, we have entity, individuals, and controlling person self-certification forms. You go on OECD, they have them for all, right? And you have ones for beneficiaries, and ones for settlers, and one for trustees, and one for protectors, right? But you always want to get the controlling person self-cert, because that's who you're reporting on. You're reporting on the controlling person, right? You need to get to the tax resident, that's the goal, and that's clearly mandated in the form, right? In the last couple pages, this is easy. US's position on CRS. They ain't doing it, right? They ain't doing it. And the OECD seems fine with that. They seem fine with that. The EU seems to be having a problem, but
They wanna be
who's gonna fight with the US now? The US say, listen, I created this thing. Now you coming for me to participate in yours when I made it? You really carry yourself, right? Now, they are doing some things to help legitimize their position, right? Remember I said banks don't have to have BOs. Even if you form a company, they don't have to have any record of the BO and all of this stuff, right? So they said, okay, we're going to do a few things. We're going to have a customer due diligence final rule, right? That's for the bank, financial institutions. That's by FinCEN. That's the regulatory agency. They have proposed beneficial ownership legislation. Never get through. Especially this all happened under Obama's last year. Never get through. Trump ain't going for that. No matter what Congress, if they win the midterms or not, he ain't going for that, right?
Didn't they do something in May, and something became effective in May for beneficial ownership?
Yeah,
Or that was for the
that's
bank?
these FinCEN rules.
For the bank?
Yeah, for the banks,
All right.
right? So now the banks have to collect BO information on new accounts. All the old, that's why there's such a rush, because it did come into effect in May. But if you had your account set up before May, you were grandfathered in. Craziness, eh?
They still require a lot of, in additional information.
Yeah.
So some of them are going back,
Diligence.
right? And the reason for that, remember I said that the banks couldn't comply with FATCA because they didn't have the information? See, this is why I think this whole US FATCA thing is short-lived. Now that the banks have it, there's no reason why the Treasury can't force true reciprocity under FATCA, which is going to have to happen. And so now the benefits of FATCA are going to be dwindled away because of this new rule. Right? So these are efforts that the United States have proposed to help deal with their beneficial ownership issues and their AML issues and try to fend off CRS. Right? So this is the rule that you're talking about. The final rule, new requirement that financial institutions collect and verify personal information of the real people, that's what they call it. Real people who own, control, and profit from companies when those companies open accounts. We've been doing that for how long?
Yeah, that's what I said.
For how long?
That's what I said too.
Right? You have to identify and verify the identity of the BO. How long have we been doing that? Understand the nature of the customer relationships. That's part of our FTRA requirements, right? Conducting ongoing monitoring to identify and report suspicious transactions. They don't even do STRs. And the FATF got nerve to say that we are deficient in AML and they need the US right off of it? You gotta be kidding. I'm so tired of these institutions. I can tell you what. My opinion is, go back to the Wild Wild West and let them blacklist us.
They do 25%, we do 10.
Right?
25%.
Switzerland does 25%. I don't know why they decided on 10. Trying too hard, and you still
Yeah.
get penalized. Right? And so that's the framework of the new FinCEN rule. Again, this is now in effect as of this year. So banks have to do this in the US, right? This ain't happening, right? BO legislation, and it ain't gonna happen. Even though the draft legislation is in place, they ain't gonna do it. But they have legislation and there is talk about it, but I don't do it. Right? And then lastly, this is the last initiative, position with single member limited liability companies, right? So, real quick, an LLC in the US that has only one owner, they call him a member, right? Is for US tax purposes, it's as if this doesn't exist, right? So that means that this doesn't have to file or register for US tax for a US tax number, for a TIN or an EIN, right? Which means from anybody's point of view, there is no US entity and the foreign guy is the foreign guy and it's done. So you can open a bank account here or whatever without a TIN in the name of the LLC, but because it's disregarded, it doesn't have a TIN, doesn't have a tax number. Therefore, the bank has no record of a tax number. It's owned by a foreign person for U.S. tax purposes, but for banking, it's an entity account. It's a complete whitewash. Can't see anything. There is nothing here. It goes away. New rules require this entity to get a TIN now. So it needs a TIN even though it's disregarded to help give it a track record, right? And when you do a TIN, you have to register who the beneficial owner is with the IRS. That's how they. Okay? That's today. Almost 2 hours. You know, I don't like to teach that long. Like 3 hours on a Tuesday night. I hope you all bring a class.
Food. I have a question.
Yeah.
When we talk about beneficial owners here, we have a lot of companies, they are required, they're supposed to file annually who are their beneficial owners.
Our legislation is draft, right? The registered agent is always supposed to know who the BO is, right? We don't file our registered shareholders with the registrar. It's kept with the registered agent. What they want us to do, except for Companies Act companies. For Companies Act companies,
Right,
shareholders are filed. For IBCs, they're not.
okay.
Just real quick, because I'm helping draft the legislation, I can tell you what it looks like. You have a beneficial ownership legislation, right? That BO legislation forces the registered agent to upload into a server with a little thumb drive the beneficial ownership of the IBCs. And beneficial ownership is defined as anybody over 25%. Okay, so we go to a 25% standard on the BO. And that registry is kept offline, theoretically, so it can't be hacked. Only one person can upload it and get the information from each registered agent. So registered agent has to coordinate this, right? And they can only get the BO information and turn it over to the law enforcement authority if it's a certified proper request from the law enforcement authority. So it's not public, it's private. It's confined with effectively criminal requests. That's the theory. We don't do very good at theory sometimes. We'll have to see how it works. But the legislation is supposed to be passed by the end of the year.
But I was asking, with companies that,
Companies Act companies?
with limited companies and
Uh-huh.
Companies Act, when they do the beneficial owner,
Yeah.
for those companies that do not, they're just keeping the one share,
The nominees?
right, the nominee shares.
Uh-huh. What about them?
how do we identify beneficial owners? Because if you have a company that's been operating 10, 15 years, you know it's profitable, somebody benefiting, and we are required to identify the beneficial ownership. Does the lawyer provide us with a certificate of incumbency or some document to say?
Gonna have to. Gonna have to. I mean, if you don't control the nominee share or the shareholders, I mean, the lawyer somebody.
You can get that from your registrar, this is.
No, but if they.
Yeah, but if they have a blocker entity in there, right?
Yeah.
Or
Unless
they
you was
they're just leaving the one share, they're not, like, you see 5,000 shares, but it's still only one share, which was the nominee people who formed the company.
They never updated the
Right.
registrar. Well, then the lawyer's gotta be fine. You gotta update your registrar. Your
We
registrar.
have a lot of those with the payment companies where we are asking for updated, like, we need trying to identify your beneficial ones, and they're coming with the updated register with just the one nominee share. So technically, we really don't know who is benefiting from the company, who the beneficial owner.
They're gonna get struck off the register.
They've been doing that for, I'm talking
Autom-
company,
automatically struck off.
well, they get no certificate of good standing.
No, when the new legislation comes in, they will be struck off. If you cannot define, if you are willfully not complying with filing the proper BO, you will be struck off.
So can we say to the lawyer, I mean, cause technically.
Which lawyer are you talking to?
No, I'm just saying the client, can we say you need to go to the lawyer and have your lawyer give us a document to say who the beneficial owners of the company?
Yes.
But they, okay. Well, these are old, like, companies we're
I
trying to
know.
bring.
The old we got the same problem, right?
Yeah.
Like, I ain't saying, because the problem we have is that if companies are companies,
Right.
the legislation is a mess. Secondly, the registry's a mess. And thirdly, just to your point, people haven't been keeping up with them because they
Right.
say, these are just local companies.
Right.
Right?
Exactly.
These are just local
Because
companies.
I had a lawyer call me
You all deal with the
yesterday.
IBCs, that's what you all concerned, these are just local
I had a lawyer call me
companies.
yesterday to say why my client need to go and update and give you a current,
Mhm.
because the share register was.
Isn't the
was
FTRA
2009,
requires it?
Was from 2009.
The FTRA requires it.
I'm giving you, the client is giving you a certificate of good standing, why do you need an updated share register?
Because the law says that's what you have to do.
No, that's not to me, I understand that, but I'm just saying,
I know.
you,
I know.
and you dealing with lawyers.
We ain't all got a good name. Only the ones that work right down the road. Y'all have a good weekend. Take care. I'm seriously fishing next weekend, so we'll pick up the last one of these when I get back.
Okay, so no class
Okay.
next Saturday.
You gotta see if y'all doing trust or not.
So no class,
No class
he
for
said
me.
Saturday.
No, he said Tuesday.
Tuesday and Saturday.
Yeah.
Yeah, he already said Tuesday and Saturday, okay.
Okay.
So it's a different class, I'll be
Christine or
I'll be seeing.
So what, we didn't have class last weekend?
No, they
No,
said.
it's only 3 of us, and
They said only 3, but remember we were saying, about them, I know it's gonna be here,
Right.
but he said it was only 3, so.
they canceled, yeah.
Yes, we did. So they canceled.
Maybe you were right.